Mr. Caceres, you are in front of us now because you have a fugitive case. You are wanted out of state of Connecticut for sexual assault. And
welcome to another jaw-dropping courtroom episode where the stakes couldn't be higher. Today, we're diving into a sexual assault fugitive case that's been brewing since 2021. A man wanted by Connecticut, now sitting in a Texas jail cell, caught in a bureaucratic nightmare involving missed faxes, incorrect phone numbers, and a ticking 14-day deadline. But here's the twist. The defense is fighting back hard, claiming procedure mistakes shouldn't cost their client extra days behind bars. Meanwhile, the judge has to balance justice, public safety, and the law. Will he walk free? Will Connecticut come to claim him? Or will a single clerical error turn into a legal standoff? Buckle up. This one's a wild ride.
He has already waived.
Yes, Judge.
And where are we at now?
So, Judge, this was originally set today, but on Friday, on a notification from the demanding jurisdiction, they requested an extension from today to the 3rd. They didn't receive notice, which I don't believe this was addressed on Friday, but they've since corrected the issue with the original fax number not reaching the detective's desk for extradition. And so they've now corrected it where this won't happen again.
So are you saying that Harris County did not fax Connecticut?
No, they did fax Connecticut, but the fax numbers that they sent it to is it has to go through, I can't remember if the name is inspector or adjuster, but there is a figurehead that has to flow through before it reaches the detective's desk, the actual extradition detective. And so on the 3rd attempt, when there was no response, is our sheriff's office reached out to their sheriff's office and finally got someone on the phone. When they were notified that same day, within, I would assume, a couple of hours, because it was still the morning, the detective immediately called Amy, who then notified me, and I talked to the detective within hours of being notified. And from then, they asked an extension to the 3rd to pick him up. For this offense, they have been investigating since 2021, and the warrant issued in 2022 is that they've been pursuing this defendant for quite a long time. And again, this was learned after our approach. I'm speaking with the detective, is that they weren't aware, they had a possible suspicion he might be in Texas, but they weren't even aware he was here. But due to the severity, the nature of the offense, where, to recap Friday, is that this was closer to a burglary of habitation, first degree, where sexual assault was committed after forcing himself into the home of someone that he knew. This was not from what they allege, it's not a dating relationship, but someone he's familiar with.
Hold on. Let's pause right here because this is critical. This isn't a trial. It's an extradition hearing, meaning one state wants this man sent back to face charges. The delay isn't about guilt or innocence. It's about a fax problem. One small administrative error could turn into a major legal standoff. Connecticut has been chasing this man since 2021, but Harris County, Texas, sent the fax to the wrong desk. Now the question becomes, should Mr. Cazares pay the price for someone else's mistake? The prosecution is arguing that the severity of the alleged crime, sexual assault after forcing entry into a home, justifies holding him longer. But the defense is coming in hot, reminding the court that without evidence, this man is presumed innocent. So how long should bureaucracy be allowed to keep an innocent man, at least legally speaking, locked up? Let's see how this plays out.
Is that because of the severity of the offense and the fact that the warrant is so old, is that the detectives believe they are not confident that he will self-surrender. And because they've already confirmed, and they sent another confirmation email this morning that they are able to secure and pick him up this Friday, is that we request no bond for this offense and the extension.
If I may, whatever the charges might be, it could be murder. It can't be murder because you can't let him out on bond. The point is he's presumed innocent. So without anything else, he is innocent as he stands here. No evidence is being presented. So if we're talking about the severity of something, he is presumed innocent. He is innocent of that as of right now. Until he gets over there to that jurisdiction, can they find him guilty of that? So presuming he's innocent, talking about the severity of a charge doesn't really have an effect on this fugitive case because there are two things that he's got in place, two things that he needs to make a decision on, whether to waive or whether to fight formally his extradition. The waiver says, what he agreed to says, they have 14 days. It is ordered for the sheriff to hold him for no more than 14 days of the date this was signed. This is the actual order signed by the court. This is what he agreed to. Signed by him, signed by you, the judge. And so this is the agreement. The fact that somebody didn't send a fax to the correct number, that's not, it doesn't say, but if we send the fax to the wrong number, you get to hold them 3 extra days. This says 14 days. This is what he signed up for. This is what's ordered. This is what I say should stand, and this is what I say should allow him to get out today. If they didn't do their due diligence for this, it's not on my client. He signed up for this.
So let me explain to you how things work, Mr. Caceres, is that the 14 days is a courtesy. Statutorily, by statute, we can hold you for 30 days. Normally, and it has become custom that we do 14 days because of the overcrowding that we have in Harris County. We have so many people in custody, 8,000, 9,000, up to 10,000 people at any given time in and out of our jails. And because of that, as a courtesy, we do 14 days. Now, many times I grant extensions, I don't grant extensions. A lot of times there are several factors that is determinant of whether I grant an extension or not. One of the things are, has there ever been an extension before? Number 2, the nature of the charge. Number 3, have you ever had a fugitive case before? And so these are things that I look at as to whether to grant an extension or not.
Your Honor, may I please speak?
Well, I don't know. You may want to talk to your lawyer. The thing is this, look, I don't want you to talk about the original case, okay? Because the thing is that I live stream these proceedings, right? And so I don't want you to say something that you put your foot into your mouth, because here, the only thing that we're discussing is whether I should set a bond for you to get out, for you to go turn yourself in. That warrant, even if I let you out today, that warrant will eternally be there, and it'll always be out there until you go turn yourself in. The only thing we're discussing now is whether I should set a bond to let you go turn yourself in. And I don't know, because are you a flight risk? I don't know. The only thing I know is that you're charged with a very serious case. It's sexual assault. And so to me, the protection of my community is paramount, number 1. Number 2, the other question I have is, if we let you out, are you going to go turn yourself in? Everyone tells me that they're going to go do that.
My family sitting in court, and they are the one supporting me. And I know 100% they're going to support me to turn myself in. That's why they're still here, and I'm still the last one. And yes, I didn't know about the fugitive warrant that I had. And yes, I'm willing to turn myself in because I'm innocent.
Now here's where the judge shows why experience matters. He cuts through the emotion and lays down some hard truth. Yes, Mr. Cazares claims innocence, and legally, he is innocent until proven guilty. But the judge has to weigh several realities here: public safety, flight risk, and whether this man will actually surrender to Connecticut authorities. Notice how the judge doesn't dismiss the seriousness of the charge, but he also doesn't let it cloud the real issue at hand: bond conditions and extradition timelines. He's not here to try the case. That's Connecticut's job. But he does need to decide: is this man trustworthy enough to walk free while waiting for extradition? And if so, what's the price tag on that trust? This is where courtroom strategy and human judgment collide.
You need to fight those charges regardless, because they're very serious charges. So Dave, what day did you say that they're going to pick
It's Friday, and I forgot to include, I know typically the court permits over objection for the 3 days, but considering the New Year's Eve is holiday, that's how I also included the...
So are they going to be here Thursday and we reset to Friday?
On Friday. And so that's why the discussion on last Friday was having it on the 6th, but if they're not here by Friday morning, is that you would potentially grant a bond.
So this is what we had planned to do, was I was going to give them an extension until Friday morning, right? If they don't come by Friday in the morning, I'm giving you a PR bond.
I came to visit my family for the holidays. I wasn't able to enjoy that. I'm willing to turn myself in, but I would like to be with my family for the New Year's to start with a strong.
Concern is not my concern. My only concern is I want you to get back to Connecticut.
And I will, but I need my family. I need to today, as the paper says, I signed for 14 days, and I would like to have a time with my family to look for the bond, to look for them to go forward with turning myself into Connecticut, but not like waiting for Friday.
Let me make one thing clear to you. This isn't about giving you a PR bond. If I were to set you a bond now, it's going to be something substantial, meaning a high bond into the 5 digits to ensure that you go back to Connecticut. This isn't about giving you a PR bond. If they fail to get you by Friday, I'm going to give you a PR bond.
Here's the courtroom's boiling point. The defense says his client is stuck in limbo because of bureaucratic errors. Fax is sent to the wrong office, miscommunication between jurisdictions, and administrative delays that have nothing to do with Mr. Cazares himself. The judge, though, reminds everyone that law and fairness don't always align perfectly. He acknowledges a 14-day waiver, but points out that as a courtesy, not a constitutional right. Statutorily, Texas can hold him for 30 days, and if he withdraws his waiver, they can extend it to 90 days while waiting for a governor's warrant. So here's the real question for you watching. If someone is presumed innocent, how long should the system be allowed to keep them waiting because of clerical mistakes? Does the severity of the alleged crime justify bending procedural timelines? Drop your thoughts in the comments. We want to hear from you.
Because they have fallen on their word twice, and I'm not going to do it. Now, if I were to set you a bond now, I mean, it's over 10,000, something like that, to that nature. And because it's a fugitive case, there's no 10%. You're probably going to have to pony up 90 to 100% of it because you are an inherent flight risk because it's a fugitive case. So there's none of this 10% where you pay $1,000 and you're going to get out. No. In these types of cases, when we have fugitive cases, I normally set bonds, 5,000, 10,000. I've set bonds at 50,000. I've set a bond at 100,000, depending on the nature, severity, how many criminal history. So this isn't about just letting you out now willy-nilly. No, I would set you a bond, and it's going to be a substantial bond because I have to know if I'm going to let you out, there's got to be enough blood in there that you're going to actually go back and not just try to flake out. Because if you take off and you don't come back, all that money's gone. So,
okay. But the 14 days were exactly what I signed for.
Remember, it is a courtesy. Statutorily, we can hold you here 30 days. Okay.
To address the legal part of it, if your client is stating that he is withdrawing the waiver after today, then at that point, if you're considering a refusal, then we'll start the governor's warrant process and we'll hold him to 90 days. So if that's what your client is requesting, just in terms of your argument, because you were stating 14 days, that's true. If you want to, at the end, then revoke it, then we'll request an extension to 90 days and get the governor's warrant. So,
Judge, my argument is what he signed, what the order states, and the documents filed in this case. This is what's filed in
I get it. I understand that. But there's sometimes extenuating circumstances. Things happen.
Not faxing it to a certain person is not a good excuse, Judge. He's sitting there waiting 14 days just because somebody didn't do their job. That should not fall on him and cost him 5 extra days. That's 5 days this man is sitting in jail. 5 extra days just because somebody didn't send a fax to the correct person. This isn't the first time.
It's a courtesy.
I get it. Okay.
We can hold you 30 days. The 14 days, I don't have to give anyone 14 days. I can hold everyone 30 days if I wanted to. 14 is a courtesy. I've told you now that I'm going to give them until Friday. If they don't come here Friday morning, I'm letting you out. And now it's on them. And I don't care. I'm going to give you a free bond on Friday if they don't come pick you up. But if I'm going to set you a bond now, the first thing that's going to happen is you have to withdraw your waiver. All the 14 days that you've accrued so far goes out the window. You lose all the time that you've accrued. If you're unable to make the bond, you've lost all that time. Then they're going to get another, another couple weeks to come get you. So give it till Friday. If they're not here, then I'll give you a PR bond. If they come here by that time, then you get up and you go fight the charges in Connecticut. Now, when you get to Connecticut, you can also, ask for a bond there. They can set you a bond there. But, the money that you would spend here just to get out, it's probably, use that to hire yourself a great lawyer there. Because the thing is that here, it's just a little wait. That in Connecticut, that's what you really got to worry about. This is peanuts. You go there, lean on your family to get you the best lawyer you can get in Connecticut so you can fight that case. That's where the concern should lie.
Thank you, Your Honor.
Remember, when you get on that phone in the jail, every phone call is recorded. Be careful what you say. Be careful who you talk to. There's a lot of jailhouse lawyers over there. They're going to tell you this, they're going to tell you that. Listen to Ricardo. He's going to direct you the best, and then we'll reset this to Friday. If they don't come Friday, I'm giving them a PR bond, and I don't give them.
Right, I'm with you. But it was remember, because the holdover issue is that it has to be set.
We'll set it to Monday.
Right.
But
otherwise he's going to be brought up in.
You'll be here Friday, right? Okay, we'll look in the system if they've come get you Friday morning. If not, if they haven't come get you, we got to set a time. What time?
Actually, they emailed confirming. Let me see if I can get a time, because they have to send it to Central Records for the pickup. So I'll see if they're able to.
We brought you here today so that you could hear what's going on, because we wanted to keep you in the loop so you know what's going on.
Thank you, Your Honor.
Okay, that's why we brought you here today, so you can hear, so you're in the know, because this is your case. You need to know what's happening.
Hopefully they'll respond soon. I just emailed the inspector over there. So it is inspector. And so hopefully he'll get back to me soon. And then
we can roll it to tomorrow. That way it gives you a little bit more time to get a concrete and firm time.
I have the date, right? If it's just the time, I have no issue with rolling it just to check the time, but every day that rolls over, he has to get brought up in the morning really early. So
what I want to do is I want to be able to commit them to a specific time on Friday. So I know I can start working on a PR bond, because I'm not giving them until 5 p.m. Friday. It's got to be in the morning, and they got to come get you. And if they don't by 10:30, then at that point I start working the PR bond for you.
Why don't we just set it for 10:30?
If I get a different time, then obviously I'll email you and I'll email court. And so
it's got to be something reasonable, morning-ish.
I think they indicated morning, but obviously until they confirm with our Central Records.
I want to know from them specifically so that they can say, "Oh man, you didn't tell us the time." And no.
Right. I only had one first specific request for an after.
I want them to commit so that they know if they're not here by that time, he's going bye-bye.
The only concern would be is if we don't do it by the time court is done with.
That's why I'm trying to commit them to a time before court is done, so that they can't.
Perfect.
It's on them. There's no one else that they can blame.
Okay. I'm on board. Yeah.
We can bring them back tomorrow if you want to do, maybe we're off Wednesday, right?
Yes, Judge.
Thursday, whatever you want, or we can email and then you can.
We could email and just, unless they wants to.
Well, I'm emailing the detective now because I emailed the inspector originally. I probably
They may not respond within,
Now the tone flips dramatically. From a serious extradition case involving sexual assault allegations to a lighthearted dispute over dog harassment. Only in real courtrooms can the stakes shift this fast. One moment, we're talking about a man's freedom and potential deportation. The next, we're discussing whether someone threatened to kill a neighbor's dog. It's a fascinating reminder that the justice system handles everything from the gravest felonies to the most bizarre misdemeanors. Should every case, big or small, get the same level of attention from a bench? Absolutely. Because to the person standing in front of that judge, their case is the most important thing in the world. Whether it's a fugitive warrant or a barking dog complaint, Justice must be administered fairly and thoughtfully. Let's see how this one plays out.
Well, we could approach on it tomorrow.
Of course.
We don't need to bring Mr.
That's what I mean. Is
Done.
Yeah.
That's what we're doing. We're going to pick a time Friday for them to come pick you up so that they are in agreement with. So if they don't come here by that time, you're giving the PR bond.
Thank you so much.
Okay? Okay, man.
Thank you.
Okay. Thank you, Judge.
All right. You're on bond for a case with us, and you've now picked up a new case. Your bond now gets revoked. He goes with you? No, sir. And we'll appoint him a lawyer today.
Relax your hands.
Thank you so much for coming. Are you Mr. Pearson's mom? Okay. So is he working? Tell me about him.
Yes, he's working a little. Ain't a political lawyer. He's in big trouble with me because I had him to do a voluntary repo on the sports car because he's not mature enough for it. He still goes.
They took the sports car.
I had him to do a voluntary repo.
Wow.
There's consequences when you don't abide.
You're my hero. Really. That's great. Mr. Pearson. She's great. You got to listen.
I made sure I enrolled him in the College of Maine. I go to College of Maine. I just graduated last May. This past May in cybersecurity. I'm an IT.
Great.
So he knows the rules.
Okay. I'll give you guys a lawyer, whatever you need, you know.
I was going to talk to you about what you can do for his first offense on this and get it over.
I can't. So let's do this. I'll provide you the lawyer. The lawyer can tell you how to move forward with dealing with the DAs, but I can't get involved at this point just because I can get in trouble for doing that. So let's do this. I need you guys. Let me see if I have an application on file. If you don't mind, I need you to fill out an application for me. Once you're done, I'll give you guys a lawyer and then you guys can work on the situation. Do you see whether he has a license to drive or no?
He has one. He has one.
Okay.
He does have one, Judge.
Great. As long as you have insurance as well, then you can continue to drive. Just be careful how you drive.
He's in my old hoopty now.
Okay, great. Okay, guys, if you want to go with Stephen, he'll take care of you guys and we'll have you sign a reset.
Okay.
Thank you so much for coming, man. How are you, man?
Good, thank you. Belated birthday, I understand. Would you turn 41?
That's cute. It's like I have hair.
I know
Let me do
you're
the
real
same now.
busy, so I'm not going to take much of your time. We have two cases, Judge. I'm Montoya Carrasco, first name Franklin. I just got appointed.
Are these in custody or on bond? Okay, so Carrasco,
To make it easy for you, he's got an immigration hold.
Okay, sorry, I was making out. Which one are we starting with?
Montoya.
Montoya. Okay.
That's the easier one.
Yes.
wait, we're talking about, okay, Montoya.
Cause number,
I got it. So it looks like she's got an ice hold, huh?
yes, Your Honor.
So whatever you want.
I need some time.
Of course.
I understand they told me 10.
However much time you need.
Okay, all righty.
Who's two?
This is, sorry, what was your question, Judge?
A little bit over a month.
No. You said you have a second person,
Yeah,
right?
second one, okay.
Who's the second one? I don't care however much time.
Okay. The other one is a unusual case. It's the first case I've ever had in my life. The last name is Orellana Carranza.
We already reset that one.
Is that the one?
Yeah.
What's so unusual?
One of them is for, that one for bail hearing, Judge. I don't know if you got the paperwork.
No, not yet, but, so it looks like this gentleman also has an ice hold as well. So whatever you want, however much time you need, it's whatever you want.
Okay.
Just,
And I got 30 days for him, but
Okay, sure.
I needed a bail, lowered bail. The bail is $2,501. He has no criminal record. The harassment between you and I, he allegedly threatened the so-called supposedly owner of a dog, that he was going to kill the dog. first case I've had that. And I can understand the argument that they're trying to make that the dog.
So
is
you
the
tell me it's a
person's property.
harassment of a dog?
Yes, now unless the dog's gonna come in and testify.
Judge, it's a little, Judge, it's a little.
The harassment is based
on him
Never a dull moment in
kill the
PJ.
Yeah, you know, I mean,
So it's based on the felony of cruelty, animal cruelty.
but it's not animal cruelty in the sense because
He also,
he didn't, it's not his dog.
Is
He
it
didn't
alleged?
mistreat the dog.
he also threatened to kill the complainant's grandmother and her boss. Like, there's more to it, Judge, than
Well,
just the dog.
If they did that, I'm certain that the prosecutor's office would file assault charges.
Well, no, harassment.
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 Harassment is because of the dog.
Well, that may be the initial, like, let's say it's a dog that barking out of freaking control, like my neighbor's dog. It drives me up the freaking wall, right? But I don't go over there and I do
You
anything
say
about
it,
it.
of course, so you don't want to admit it, right here, but
Is that what happened here?
that's what they
The
said.
incessant barking?
We already added an eval for it. We're already gonna look at this case. We're gonna look into it.
What I want is them to dismiss it. First of all,
Oh, I see.
the ownership of the dog. They have to, by law, have to register the dog, they have to chip them. And I follow those rules, Judge. I never violate the law. I don't want to be coming in front of you and say, "Please, Judge, give me the bird, please. I won't do it again."
So,
So,
look,
okay.
however much time you want, if you want to set it a week or 2 weeks, there's an ice hold, so there's really nothing that we
Yeah,
can,
I'm waiting to bill here.
okay, whatever you want, Tony, you got it. Just- The only thing I'm gonna ask is if they are able to bond out, like they get an immigration bond,
Yeah, I'll let
please
you-
let them know they gotta come here so that we can do conditions so that they don't.
So are you saying you're willing to give them a PR bond?
Well, I don't know. Because if we do that now, they may get shipped off to immigration and that's gonna put like a 3-month halt on everything. It's up to you,
They're carrying
but be
judge.
careful what you wish for, as they say. You know what?
And I have not
So-
asked for bail certain individuals, but I think maybe it's appropriate for him to at very least consider the PR bond or maybe $100 secure bond.
You tell me. But don't, take your time. There's no, you don't need to do it now. Just let me know.
Well, let's do $100. If push comes to shove, if he really wants,
Well, here's the thing. So on this gentleman, on Oriana, he took off on us. So
no,
we
it
did
wasn't
give him,
Ariana. It was the other guy, Montoya. But he's been to immigration. He's already
Well,
been immigration.
technically, yeah, he did take off for about
both
a
of them
month and a
take
half.
off on us. And we
That's
got back in
because that's
custody.
because he had a pending case. He's been in custody.
There's an immigration. That's
And these are the-
Yeah. Okay.
So
Hit it,
it's Ariana, the older one, but we've got so many discovered to go. So I'll tell
Oh, okay.
Victoria. On the Oriana, if you would consider at least $100. He doesn't have a criminal record.
We're just
They
gonna,
charge him with what I think, I have 2 dogs, by the way.
Judge,
The next door dog keeps on barking.
It looks like we gave him a GOB and he took off. Right? He took off and then he got
The
rearrested.
prosecutor will tell you that he was in another county, Fairfield
we're,
County.
Let me do
we're
this.
looking, we're looking
I
at
Mine is
that.
getting long.
I don't see any other charges or,
And he's been in immigration. They lifted.
I know.
the
why was
hold.
he in immigration?
He wants $100 bond.
So, I mean, Judge, the state would be against reducing the bond just because
If he,
it does seem like.
if he was given a GOB and he took off and we had to rearrest him and get him back, I'm not giving him a $100 bond.
They transferred him directly.
Show me and then I'll give you the $100 bond.
Would you allow us to just, I would like to look into this case, just his criminal history a little bit, because I don't know about an out County, so.
I don't know. They do research.
Either way, Judge, he does seem like he's a community risk.
Okay, you're talking about which one? Oriana?
Oh, whoever you want.
Okay, Oriana's the one I want to bail.
Done.
The other guy, I waived for
Got
a
it.
lot of reasons.
Okay.
But Oriana, I gotta figure out whether he was transferred from immigration to here, because they lifted.
Look with Trey. Trey can tell you.
Okay, all right.
Yeah.
May I be excused or?
Tony, always a pleasure.
He
You
showed
never
us,
volunteer, you tell me not to volunteer.
he showed us pictures of his dogs. They're very cute.
As long as they don't
But I got the
incessantly bark.
dogs next door, 2 of them, at 3:00 in the morning, they start barking.
Yes.
Who do we have here?
This is Ms. Holman, and Ms.
Okay.
Strong is representing also Ms. Padilla. They both were pleased.
Right. Good morning, Ms. Holman.
How are you doing, Your Honor?
And you are charged with theft. You're facing up to a year in jail and or a $4,000 fine because of the amount. You guys have worked out an agreement where on your case, they're offering you 8 days in jail with credit for the 8 days that you've done. Good morning, Mr. Medrano. You speak English?
Yes, sir. Well, my last name is Diaz.
This is Diaz here.
No, sorry.
That's okay. Both of you guys are giving up a lot of rights by entering into the agreement that you guys have now. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you guys are not citizens, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do, Ms. Holman?
Yes, Your Honor.
Like I said, you're charged with the theft. You're facing up to a year in jail and or a $4,000 fine. The thing that you need to understand, ma'am, is that this is an enhanceable offense, meaning that if you continue to pick these up, at some point they will charge you with a felony and you're looking at days instead of years.
Yes, Your Honor.
8 days in jail, credit for the 8 days that you've done. Is this what you want to do, ma'am?
Yes, Your Honor.
How do you plead to the offense of theft? Guilty?
I plead guilty, Your Honor.
I will find you guilty, sentence you to 8 days in jail, give you credit for the 8. Good luck to you, ma'am.
Thank you so much.
Sir Diaz, you are charged with criminal trespass. You've worked out an agreement. They're offering you 27 days in jail, credit for the 9 days that you've done. Is this what you want to do? How do you plead to the offense? Guilty or not guilty? I will find you guilty. I'll send you to the agreement. Good luck to you, sir. Thank you. If either are enhanced, it needs to be abandoned, please.
And Judge, you want CC for them?
Please, always on jail costs.
Gotcha.
Always. Okay, counsel, come on up.
This is an off docket. Tell me when you're ready for the case number.
Tell me.
254-3247, Daniel Arevalo. This is a case of an ounce of prevention, hopefully is better than a pound of cure. I got on the case after he'd already appeared in court and got his bond conditions. He has random urinalysis. He travels a lot.
What does he do for
September, 7 days, 18 days in October, 21 days in November, what I would propose.
What does he do for work?
Construction, and would you like for him to?
Sure.
Come on up.
So this is what we normally do when they get called upon. They have to go to a Quest Diagnostics, wherever they are. Quest is all over the country, and they need a test at a Quest because it's a reputable lab.
I mean, we're talking Montana and Wyoming at times. What I was going to suggest is, could he call pretrial on Monday and give them his schedule and take a portable breath device?
I'm okay with that. Sure.
Okay.
Yes.
That way they can work.
I'm happy to do it.
Schedule.
Yep.
And it's a DWI, so we're making sure he doesn't.
Done.
Okay.
Sounds good with me.
I'll let the pretrial know.
Yeah,
So portable, no more mandatories, correct?
correct. Waive the fee. Are you ready?
Yes.
It's 254-3247. Okay, good luck.
Thank you, Your Honor.
And there you have it. A full day in the life of a courtroom where every case, from high-stakes fugitive extraditions to barking dog disputes, gets its moment before the judge. Let's recap what we witnessed today. In the Cazares case, we saw the collision of legal procedure and human desperation. A man accused of sexual assault sat in a Texas jail, waiting for Connecticut to extradite him, while bureaucratic errors. Faxes sent to the wrong office threatened to extend his detention. The defense argued passionately that their client shouldn't pay for administrative failures, while the prosecution emphasized the severity of the allegations and the need to protect the public. The judge, balancing statute, courtesy, and fairness, ultimately gave Connecticut until Friday morning to pick him up, or he'd issue a PR bond. It's a perfect example of how the wheels of justice sometimes grind slowly, and how even small clerical mistakes can have massive human consequences. Beyond that, we saw plea deals, bond negotiations, immigration holds, and even a bizarre case involving alleged threats against a dog. Each person who stepped before that bench had a story, a struggle, and a stake in the outcome. The courtroom is where law meets life. And today was a masterclass in how judges navigate that intersection with wisdom, patience, and a touch of humor. If you found this case as shocking and compelling as we did, make sure to hit that like button Drop your thoughts in the comments below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We bring you the drama, the legal insights, and the real human stories behind the cases. See you in the next one.